Thank you so much, Odi, for the very kind introduction. It's a real pleasure to be here today in Tallinn with a full house. Wow, that's exciting. And I'm very happy to be here today to launch this handbook on developing a national position on international law and cyber activities, which was co-authored by Professor Kubo Mačák, who is also here on this panel, by myself and Dr. Agnes Kasper, who's also here, and we're just very excited to be here today. So the aim of this panel is to not just launch the handbook, it's not just a publicity stunt, but it's to really unpack what this handbook is all about, why we decided to do it, what the handbook really deals with, what it is for. So this is what we're going to try to unpack in this discussion. Really, to give you a little bit of context and background about this project, and it was a long project. We actually launched it about exactly a year and a day ago, as Kubo was telling me the other day, here at CyCon. I don't think it was the same room, but in a different room. But anyway, Kubo told me that there is a Slovak saying that if you want to get something done, you have to do it in a day and a year. You said you wouldn't say it, but I decided to steal it from you because I thought it was cool. But actually, it didn't just take a year and a day to do this. And the idea to do this handbook actually started almost 2 years ago, I would say, also at CyCon, behind the scenes in the hallways, in conversations that we had, when we realized that national positions on international and cyberspace, as some people like to call it, were gaining a lot of momentum. They started in 2012 with a speech by U.S. former legal advisor Harold Cole, but then lots of states started to do that. And so we started to see this trend where, states put forward their views. They published these very detailed positions on how they understood international law to apply to cyber activities. And we thought it was interesting because in no other area of international law have we seen something like this. So we thought this was an interesting phenomenon and we wanted to unpack it. But there was a problem. Most national positions at the time, they had been published by global North states. A lot of global South states at the time remained silent. And so we thought, well, why don't we do a resource that can guide states from all over the world, the global South, the global North, whoever wants to put forth their views on international and cyberspace, let's guide them through this process. Let's do something that's useful for them. So here we are. This is the handbook, and it really seeks to provide some practical guidance for states developing or reviewing their national positions. So many states have published several positions over the years. They might want to change their views on one or more topics. And the book talks about the key legal implications. It talks about the motivations. It talks about the procedural steps, the substantive legal issues that these positions cover. It also talks about effective presentation strategy. So national positions have been presented or formatted in so many different ways. There have been speeches, documents, and so we unpack all of that in the book. And this book wasn't just an academic exercise where we sat down at our desks and wrote, something cool about international law. It wasn't just that. It drew from insights from 46 states from the global North and the global South that participated in regional roundtables that we held in 2014 in Washington, D.C., and Singapore and Addis Ababa. And of course, this handbook is not just a project that Kubo, myself, and Agnes put together, but it was a collaborative project. So we couldn't have done this without the support of our partner institutions. So it's a project that's led by a consortium of institutions that comprises the University of Exeter, the Ministry of Foreign Affairs of Japan and the Ministry of Foreign Affairs of Estonia, as well as NATO, CCDCOE, of course, which is why we are here today. And the project also benefited from the support of other partner institutions, and in particular the African Union, which we have represented here today, the Organization of American States, the Foreign Office of the Federal Republic of Germany, the Center for International Law at the National University of Singapore, and the Tallinn University of Technology. And I'll end my introductory remarks there. So I want to introduce our speakers, our fabulous speakers for today. So we have Professor Kubo Mačák, who is Professor of International Law at Exeter University and also a Senior Fellow here at NATO CCDCOE. Please, let's hold some applause for Dr. Mačák. We also have Dr. Agnes Kasper, who is the head of the law branch at NATO CCDCOE and also a senior lecturer at Tallinn University of Technology. We have Professor Mohammed Halal, who is at the moment the legal advisor to the permanent mission of Egypt to the United Nations in New York City, but also the African Union Special Rapporteur on International Law and Cyberspace. We also have Dr. Katsuhiko Nakamura, who is legal advisor and Director General of International Legal Affairs at the Ministry of Foreign Affairs of Japan. And last but not least, we have Dr. René Vark, who is Associate Professor of International Law at the School of Law at the University of Tartu. He's also a member of the Permanent Court of Arbitration and also the legal director at the Estonian Ministry of Foreign Affairs. So thank you all for being here today for this discussion. The way it's going to go is that we're going to have a panel discussion, an informal discussion with the panelists with a little bit of back and forth, and then we're going to have some time at the end for a Q&A. So let's get this started. And if I may, Kubo, turn to you for a little bit more background about this work. What's the structure of the handbook? What is this handbook trying to achieve? What are its main takeaways?
Thank you, Talita, and thank you for the really kind introduction, also of the overview. You took me by surprise by even quoting the Slovak proverb. So yes. For any Slovak speakers, it's do roka do dňa. Yeah? So now it's mentioned that you do something within a year and a day, exactly. How many in the audience were here with us for the launch of the project, just by interest? Can we have hands up of people who were here? A couple of people, yeah, but definitely not everyone. So yeah, we're really delighted that you all have decided to join us now when we present the outcome of this project. It was really a whirlwind, I would say, of the past 12 months. Last year, in the parallel, introduction of the project, I said, next year we're going to come back and we will present the handbook. And I remember Agnes looking at me like she's looking at me now with these eyes like, are you sure we should have said it publicly? But look, here we are, the book is out. So, and we hope that those of you who are among our intended audience, which is mainly, of course, state officials who are involved in the preparation of national positions on international law on cyberspace, but also their colleagues working for the government, also academics, scholars that are interested in this general field. We hope that you will find it a useful resource in your work. So you asked me about a bit more about the background of the project. I think you introduced very well, where the idea came from. I would just add a word of thanks from my side, also to you two as my two co-authors, and to the institutions that form the partnership, all the institutions that you have mentioned. We also benefited from the financial support of the Economic and Social Research Council in the United Kingdom as a grant. We received a grant which made it possible for us to organize many of the project events. What all of you might be interested in is that this isn't just an academic project in the sense the three of us would get together and write down our views. Far from it, we actually often had to sort of reserve and take a step back and say, yes, we have our academic views on what the what states should do, but this is not the right place for that. And so in order to be successful in doing that, we organized the 3 regional roundtables that Talita mentioned. And so we organized them on the basis of where we felt from states that the need to develop this discussion was particularly profound. And so those 3 regions were the Latin American region, then the region of the Asia Pacific, and the region of the African Union, or Africa. So we held 3 of these regional roundtables. In total, we had almost 80 officials from 46 states participating. And so the result, the handbook that we already have here, you in the audience don't yet, but you will hear at the end of this session where you can get hold of it, draws on those discussions. And so the key takeaways of the handbook that you also ask about, so things like what are the best practices when states are working on their national positions? What are the substantive legal issues that are covered in these national positions? They all draw on these discussions with state officials that come from, I would say, 3 categories of states, most broadly you could say. There is the category of the 33 states that have already issued their national positions. So they have come to these meetings. States representing this category have come to these meetings saying, yes, we have this experience that we can share with you all and you can learn from it. Then the second category of states are those who are considering it, who are interested or are in the process of working on a national position. And it was very interesting listening to them about the hurdles that they face. We could be here the whole day, but let me just give you one example, and that's the interagency dynamics. Because in many of the states, the national position is not just the product of one person who sits down and says, here it is. But it's a collaboration between the Ministry of Foreign Affairs, Ministry of Defense, intelligence agencies are often involved, the Office of the Prime Minister, it could be a plethora of agencies. And so this interagency dynamics is another thing that we have heard from, and a lot of it was from the second category of states who are now in the process of working on their national positions. But then there is also the third category of states that haven't started this work yet, but were interested enough to join us, and it was very interesting to hear their perspectives. And one of the chapters of the handbook is called simply Motivations. And it answers the question of, should we even do it? What are the motivations of states to engage in this discussion? And it's great that we have Kazuhiko and René, who are representing Japan and Estonia as states who have issued their national positions, and you will hear from them, why they decided to do so. But there was a degree of skepticism, and let's be open about that, and the handbook also captures this degree of skepticism and the discussions that states had, whether to adopt a national position, when to do so, and how to go about it. So that's by way of a little bit more background, and just the last word, because you also asked about the structure, and I have already hinted at it. So the structure of the handbook really reflects the demand that we felt from states, the questions that they were asking, and it consists of 4 main chapters. So the first one is the one I just mentioned, motivations. It's the first question that you have to ask yourself. Should we even do it? And if so, why? Then the second question is the next step. If you decide to do so, if you decide to work on such a national position, the second question is, how do you do that? And so the second of these chapters is just called process. And so it looks at the various procedural steps that states might take, including, choosing who the pen holder would be and who are these agencies involved and so on. The third of these big chapters is probably the biggest in the book, and it's called simply substance. It's about the what you put in these national positions. And it maps out the existing national positions and the regional positions, and we have Mohammed on the panel who will for sure mention the common African position, and also there is the common position of the European Union. And so this chapter maps out these positions and looks at the convergences and divergences of views among the states. And then the final of the chapters of the handbook focuses on, once you have all of that done, you have decided to do it, you have gone through the process, and you have decided what to include in your national position, the final step is how you present it to the world. Yeah? So what is the format, what is the style, what are the language choices involved? And that's the final chapter. So I hope that answers the question.
What is the main takeaway? What would you say in one sentence?
I think the main takeaway is that it is possible to catalog all these best practices and put them in one book that you can lift it. It's not very heavy, and you can learn from it. You can learn from the decisions of other states, but also what we heard a lot, and I think all of you who were at the roundtables will agree with me, was this phrase, no one size fits all. And the handbook reflects that. It doesn't prescribe a process, you have to do this. Even the chapter about the process offers options, the options that have worked for different states. So yeah, I think those are maybe the two main takeaways.
So this is not a cookbook?
It's not a cookbook.
Great. Okay, so thank you so much, Kubo, for that. Agnes, as the other co-author of the book, can I ask you to, talk a little bit more about what is a national position, what is the legal status of a national position, and what functions does it serve? So let's go into the weeds a little bit of what this is.
Okay, thank you very much, Talita. Thank you very much, Kubo. So thank you very much for the team and all the partners who supported this project and their immensely valuable contributions to the book. So national positions. What is a national position? So let me shortly say that these are carefully crafted statements where states articulate their positions on how, in their view, international law applies to conduct cyber activities. So shortly. So in itself, having a national position or views on how international law applies, this is not a new phenomenon, but states routinely express their positions on various aspects of international law. However, with regards to cyber activities, there seems to be somewhat of a qualitative difference here. So what I think, it's many of these are actually comprehensive statements on a very broad spectrum of international legal issues, which this was not the practice before, as you already explained, Talita. So that's one of the differences here. So, and then there are also more than 30 states or in 2 international organizations. So the African Union, the European Union, who actually decided to make these statements public. So maybe these are the qualitative differences. And for the purposes of the handbook, we focused on the statements that, yes, first, these are issued publicly. So the documents and these statements need to be available to the general public rather than shared in closed-door negotiations or forum. So also it needs to be, for the purposes of including it in the handbook, these are issued by a state organ. It can be, by the Ministry of Foreign Affairs or Prime Minister's office, but the point is that it needs to come from a state organ. So also they need to be available in a written format in a public repository. So this is when we included these national positions. So which was published in its entirety in a format intended for long-term public accessibility. That's where we looked at the position. And also, importantly, those statements we looked at, which were published with the aim of actually expressing specific legal views on the application of international law in the cyber context. So, but let's go, okay, we have these national positions now, but why would you issue a national position? What does it do? What the legal policy or practical significance of these? So first, to the legal status. We had extensive discussions about legal status of the national positions during these project events, but I have to tell you that the discussions were inconclusive. And this question remains unsettled, that what's their legal status. And also these national positions are mostly silent themselves on this question. Even those that discuss their broader aims, they frame them as efforts to promote legal certainty or foster common understandings rather than make an explicit claims about their legal significance. Some of the national positions state their aim, for example, stating that, okay, we aim to develop customary law, or when positions say that we further a view on some legal new potentially arising rules. So few participants, on the other hand, questions whether these national positions are more than policy documents, policy statements, but most of them agreed that these national positions do have legal significance. Now, what exactly the legal significance? Yeah, there were diverging views on that, but there was an agreement that yes, they have a degree of legal valence. Yeah, is from technically, if you look at it, I mean, the statements, the national positions, they do have these broader statements in some of the parts. So you can say, okay, this is the policy behind. But many of the formulations, you can look at it as, for example, they would be interpreting treaty law. Yeah, so that's one of the options. That's one of the possibilities that they actually contribute to the interpretation of different treaties. For example, such treaty could be the UN Charter, or such treaty can be the Geneva Convention. So about those rules that they are unpacking, that they are commenting on or clarifying, so these can qualify as treaty interpretations. Other way to look at it, that some of the statements can also refer that, okay, these statements qualify as contributions to customary international law, for example. So some states affirm a customary nature of a particular rule or a set of rules, for example, on prohibitions of intervention or the use of force or rules of state responsibility. So on some occasions, states invoke custom in the negative. That what is something that they consider not international, customary international law. So we looked at these possibilities, like what could be the legal balance of these, but also we understand from the roundtables that beyond the legal balance and the legal functions of these national positions, they also serve different functions, more broader functions. For example, the communicative function that we noticed that simply having a national position, states want to communicate internally and externally that they are playing by the rules of international law, and they want others to do the same. So it's just simply telling the word. They also, these national positions have these transformative functions. So shaping international law, adjusting the current framework, and the preventative or deterrent function also. By clarifying the rules, there is an expectation established by the circumstances when would a state consider a certain behavior violation of international law. And there is this potential that these violations can draw, legal consequences. So as such, these national positions also act as a deterrent or preventative functions. So there are divergent views on the legal balance and exactly the aims of the national positions and their precise role, what will be in the future, what we will do with them in the future. So, but there is definitely a need for further state engagement and also academic research on these issues. So thank you very much. Over back to you, Talita.
Thank you, Agnes. So that's a good summary of like the multitude of legal statuses, if you will, or the multitude of legal purposes and policy motivations as well that national positions can fulfill. So turning to one person who was behind or helped formulate one common position, and that's Mohammed, Professor Halal here, who helped develop the common position of the African Union. So in your experience, Mohammed, and drawing from what Agnes has said about the various aims and legal policy aims and legal aims of national positions, in your experience, do you see any of those aims or objectives or motivations reflected in the African Union's common position? And to what extent do you think that those would extend to national positions? Because they're slightly different, right? There are different actors involved, and so it's a different process, different aims. So can you talk us to us a little bit about that?
Yeah, absolutely. So what I'm going to do, I'm going to tell you a story.
Okay.
And here's the story. Basically, there were two core motivations underlying the common African position. The first is legal, and the second is policy. And I say that deliberately. They're first and second, because that's how the process evolved. It started off as a process that was principally motivated by legal considerations. So we here, this is not a royal we, this was the legal council of the African Union at the time, a dear colleague from Burundi, the chair of the African Union Commission of International Law, a colleague from Tunisia, and myself. And we were concerned about the systemic effects on international law of this conversation. And the basic concern is this, that many of the national positions that had emerged until then were presented as expressions on the scope and content of rules of international law generally, and not just as they apply in cyberspace. If you look at how these national positions are framed, they tell you this is what sovereignty is under general international law. This is what the prohibition on the use of force under general international law requires. This is what non-intervention requires, rules of humanitarian law, and so on and so forth. And then how they specifically apply in cyberspace. So the first concern was, we are concerned about how this conversation affects the evolution of all of international law. In short, it's recoding international law. So we basically took this to the Peace and Security Council, which is sort of the Security Council version of the African Union, and the states were interested. But I'll be very honest, at the time, it sort of sounded like maybe a conversation that folks here would be interested in, a nerdy legal conversation. And the member states were interested enough to say, okay, please write a common position for us as a continent. But then, and this is a story about the unintended consequences of malicious cyber operations. In late March of 2023, the African Union was the target of a major cyber attack, which in legal lingo, it affected the functionality of the IT systems of the Union and even led to the Union had to replace some hardware. So that completely changed the calculus, and that's where the policy imperative came in. Immediately, the Peace and Security Council held an emergency session, and it came out with a number of decisions, including having to leverage resources to build more national certs in the continent. It established a unit on cybersecurity in the political affairs department, so basically taking it, this is not only a technical conversation, but also it basically created a unit that approaches these questions from a political perspective, and it basically said, where is the common position? You've been working on this for all of 4 months, and you need to get this done. And the resolution from the Peace and Security Council actually says, please finish this expeditiously. And so that is the second part of the story, is that there emerged a policy imperative, and that's where in the handbook you talk about the preventive deterrent value of these national positions, or in this case, a regional position. And so, now having been instructed to finish it expeditiously, I finished the first draft, submitted it, it went through the bureaucracy of the Union, that it was submitted to the Peace and Security Council in its initial version in August, and then we created a working group that, and this is really an important part about the how-to. This was a multi-stakeholder process. So this working group that we established included the legal portion of the sort of like the legal architecture of the African Union, but also the tech folks, so the folks that do the information technology policy, but also the IT experts from the Union, and the Committee on Security Services and Intelligence. So this is a part of the African Union. It's an organ of the African Union, which is a consultative and coordinating body of security services, and the 55 member states. So this was all the member states and everyone in the architecture of the African Union that is involved in questions of cyber, whether policy, tech, or law. And that's basically how it was developed. And then it was submitted again to the Peace and Security Council, adopted unanimously, and then adopted by the heads of state and government of Africa in February of 2024. So that's the story. And another part of the story, which also appears in the handbook, but also appears in the common position, is the importance of capacity building, right? It was where this process was not just a bunch of lawyers sitting in a room drafting views on the scope and content of rules of international law, but we also had a capacity building program that was co-organized and funded by Global Affairs Canada, which was was our colleagues from Cyber Law International delivered it, and it was online. It was in New York. It was in Addis Ababa with almost 200 participants. And this is also part of the story where you created momentum and you engaged people in various government agencies. And you created buy-in. They sort of all felt involved in the process of developing this document. So that's basically the story of how this instrument was developed.
Thank you so much, Mohammed, for sharing that story with us. And yes, I second what you just said about capacity building. And there are lots more states who need it. In Latin America, there was an attempt to try and pull the views of states in Latin America on international and cyberspace, which was unsuccessful because of a lack of capacity. Eastern European states still are not represented in the national positions so far. There are a few Asian states that have published a position. So Middle Eastern states. So we need more capacity building. Totally with you there, and the importance of multi-stakeholderism and developing these positions. And it's funny what you said about the systemic implications, because it's really like, I think what you said once, that what happens in cyberspace does not stay in cyberspace. So this is very important, not just in the cyber context, but for international law more generally. So I want to turn now to Katsuhiko, and representing Japan here. And Japan was among the first states to publish a national position. And looking back, at the process of publishing that position, the motivations, do any of the steps or the methods that were described in the handbook's chapter on the process of developing a national position, did they reflect Japan's experience? So what was that like for you? And building on that, also, do you see any reflections of the chapter on the substance or the content of national positions? Do you see them resonate with how Japan chose to, the topics that it chose, and how to address those topics in its national position? Over to you.
Yeah, thank you. And would like to elaborate based on Japan's experience in developing and drafting national positions, the relevance of several points made in this handbook, maybe 3 points. Firstly, I took note with great interest the handbook's approach in highlighting importance of the involvement and inputs from various stakeholders, not only governmental actors. And in this context, we, as Japan, really relied very much on the actually academic circles inputs in terms of international law. To put it more concretely, before actually starting the drafting process among the government agencies, it was, I think, in 2019 or beginning of 2020, we first started by taking stock of the accumulation or achievement of the negotiations, discussions as of 2019 or 2020, both through the intergovernmental process, such as UNGGE, UNOEWG, etc., on the one hand, but also the achievement of the academic discussions, or such as the Tallinn Manual 2.0 or the Oxford process, which actually precisely with the perspective I've just explained, Japan has been very closely involved and co-sponsored even some of the events and projects. And so taking stock of and drawing useful inputs from these past achievements also, we also embarked on a sort of informal contacts with academia or other knowledgeable experts to, from time to time, check and test our thinking, either before starting the drafting process and during the drafting process, and even after the development and publication of the national positions, which definitely was helpful. So in this context, so at least as for Japan is concerned, the existence of a certain critical mass about the knowledge, legal thinking was critical for us to enable us to really develop and draft national position. That is my first point. Regarding the second point, which is closely related to the chapter for substance of this handbook, the topics or areas of international law listed therein globally and approximately corresponds to the points we made in our national positions. But maybe if you have a read through our national positions, many of you might notice that our national position paper is quite concise, and we elaborate more on some of the topics, such as sovereignty, due diligence, circumstances precluding wrongfulness, but less on others. For example, although we mention and refer to the international human rights law, but the elaboration on this topic is slightly less than the topics I've just explained, and we haven't really entered into the details about international criminal law, as well as the self-determination, and all that reflects a sort of kind of priority we put from the policy perspective, so to speak. The main objective of Japan's developing of national position was to share common understanding on how main provisions, main rules of international laws apply, and by so doing to deter malicious cyber operations at the same time worldwide and against Japan. So that means that we elaborated more on those rules or areas of international law which we believe to serve this objective more than others. And talking about several points on which we didn't quite elaborate much, it relates to the first point I made. We thought that the critical mass of the both intergovernmental or academic circle discussions have not reached such critical mass on these topics. That was the main reasons and background of our thinking. And as the third point, the handbook refers the utility and significance of the interagency discussions during the drafting process, irrespective of where, irrespective of whether that process results in the development of national position actually, or the publication, or its publication. I cannot but fully agree, because we recently had the experience of passing our new legislation on active cyber defense in our national diet, during which the discussions we've had among different agencies and ministries in drafting and develop national position served a lot to kind of frame the international law perspective discussions and the structure of this new legislation. To indicate some examples, in our national position regarding particularly the sovereignty, it reads that an act of causing physical damage or loss of functionality to critical infrastructure by sub-operation may constitute a violation of sovereignty. This may wording implicitly suggests that there can be a room for a cyber activities operation that can be legal, that does not violate the sovereignty below the threshold of this critical infrastructure discussion. And on the other hand, in our national position too, we also very clearly referred to the possibility of invoking circumstances precluding wrongfulness, such as countermeasures and necessity. And those arguments are fully shared and consolidated among different government entities first, and which really formed the basis for this new legislation. And so this example and this experience very clearly shows the point you made on the usefulness of interagency coordination.
That's a very powerful example of how international law impacts or can have a positive effect on domestic law as well. And you illustrated very, very clearly how different states have different motivations, different cultural, political, social backgrounds and priorities, and how that influences how it's going to select the topics and how it's going to do the process of developing a national position. And so on that note, I want to turn to another example of a country that has issued 2 national positions, one of which here at CyCon in 2019 as a speech. And that's Rene here representing Estonia. So Estonia has its own national priorities, its own styles, its own traditions. And so thinking about that and looking at the handbook's chapter on the presentation or the format and style and dissemination of national positions, and that chapter notes that there are different ways of doing that, of presenting national positions. Can you talk to us a little bit about Estonia's choice? Why did it choose to do a speech, and then it issued a document, a longer document as part of the GGE compendium detailing its position? Could you reflect on those formats and why they were important, their pros and cons, their impact? Can you share with us a little bit of that story?
I hope so. But first, congratulations to the whole team for publishing this handbook. It's a notable achievement. I have actually read the early edition, and I seriously think that it helps to understand why and how to develop national positions. And I hope that it actually inspires states to undertake this endeavor, either by preparing the first national position or updating existing national position. So when it comes to the format, it's interesting to read the chapter that how there has been sort of a development or evolution, if you will. We started with rather simple positions, and now we have these sophisticated standalone documents. So the handbook shows that there have been more or less speeches, statements, standalone documents, and even academic articles. And of course, it's for every state to decide which one to choose. And the handbook also nicely presents the pros and cons of each format. So states have to assess, for example, what is the target audience, how sophisticated they want to make their national position, what topics to cover, what is the level of detail, and also the time and effort they want to put it. So when it comes to Estonia, of course, everyone knows Estonia has consistently maintained that international law does apply to cyber activities. Cyberspace is not a vacuum when it comes to law. So it was only natural that Estonia made its position known to the world. And indeed, the first Estonian national position was delivered as a speech by the president here at the CyCon conference in 2019. And if we use the modern word, it became rather viral, and it is still frequently cited. I think it is because in that speech, Estonia showed support to the idea, to the concept of collective countermeasures. So Estonia still believes that under specific circumstances, collective countermeasures are permissible, and they are actually necessary to protect these underlying norms and principles in international law. And the speech managed to cover surprisingly many topics. So if you look, the speech is not that long, but there's a lot of things mentioned: sovereignty, state responsibility, attribution, due diligence, use of force, armed attack, self-defense, and so on. However, as the discussion and real-life experience got more nuanced, states started to issue national positions as standalone documents. When in 2019, the group of governmental experts invited states to submit voluntary national contributions, Estonia decided to use this opportunity to update, but also to expand our national position. For example, going also into the human rights law, international humanitarian law, and so on. And we know that altogether 15 states contributed, and their contributions were published as a compendium in 2021. So it's a good start in a way. And for me, if I may add, it's not surprising that standalone documents have become the most popular format, because they allow greater coverage and also detail. And states can take their time to prepare these documents, and they can, calmly decide what topics to cover, and they can also familiarize what others have said. So it's a great opportunity. You can also include the footnotes and make it really sophisticated and nice looking. Now, of course, years have passed, things have changed, things have happened, more states have published their positions. And we here in Estonia have also become more knowledgeable and also more experienced. And that is why we are planning to update again
our position.
National position. Now we hope to begin the work in coming months. Our aim is to make our national position again more sophisticated, perhaps add some new areas, and of course make our arguments more detailed. It will be an interagency project, of course. The Ministry of Foreign Affairs will lead, but we will closely work with other ministries and authorities in order to make it a truly standalone document. Of course, in electronic format. Electronic format is always nice because it actually increases the accessibility. And if your national position is accessible, then it can also have more impact. So, for example, if you choose the format of an academic article, that is always, problematic because many academic articles are behind the paywall, so they are not actually accessible, and also non-lawyers probably will not find it, and the impact is limited. So anyway, I applaud that you have finished this handbook, and I encourage everyone to read. It's useful.
Thank you so much, René, for sharing your experience, for sharing your thoughts. And yes, presentation is not just about form, it's not just about style. It really matters, and it really reflects the state's, policy considerations, but it also affects the impact of a national position, as you put it very well. So on that note, I want to open up the floor for questions from the audience, if we have any. Does anyone want to start? Yes, the gentleman over there. Thank you.
Thank you very much. I'm Patrick Junkuns, and I would have a question regarding the collective countermeasures. The question would be, are they needed? So from a political perspective, if you choose to go for countermeasures, I have to say I'm not a lawyer, right? So I'm needing legal advice, and I'm expecting 7 opinions from the panel now. But the question is, do we really need those? If we go out and apply countermeasures, it's a political statement, but that political statement could be delivered in different ways, like with collective attribution. We are standing together with that nation that is taking these countermeasures. And practically speaking, if we need the means of another nation that we do not have at our own disposal, can we not apply those means in a way that from an international law perspective should be considered the means of that specific nation? So if we go out and take those countermeasures with a civilian company and it's contracted, wouldn't that account for being the countermeasures of that one specific nation instead of collective countermeasures?
Can I just take another question before we... Yes, Russell.
Hello. Thanks very much, and congratulations to you on the publication of this excellent resource. My question is whether the handbook takes a position on the legal status of national and regional positions. Are they state practice? Are they opinio juris? Are they both? Or are they neither? I've certainly been at cyber events recently where certain individuals have said that these statements merely reflect how states think international law should apply or may apply to cyberspace. So in that sense, these statements don't have any legal precedential value. That's not my view, but I was wondering whether the handbook takes a position.
Great question. And I'll take another one from the gentleman over there, and then we're going to turn back to the speakers.
Thank you. Paul Banger, Stockholm University. Thank you for a very interesting panel. I have two related questions. The first one is, since this is an area of law which, well, there's a fair degree of uncertainty, I think that there's a bit of a wiggle room for states to also introduce policy considerations in their positions. So I'm really interested in hearing what your reflections and your experience, in particular from the legal advisors. And related to that, who are the stakeholders that have relevant views for the policy considerations? I think you mentioned Ministry of Foreign Affairs, Defense, Intelligence, perhaps also tech companies, but there are also other stakeholders with more diffuse interests, like non-tech industry, and justice, human rights, and so forth. Mm-hmm. And have they or should they be involved in those deliberations? Thank you.
Thank you. That's a great question. So let's start with the question about collective countermeasures. I think that was for you, Renee. Sorry to put you on the spot.
Yes. If I'm not mistaken, this afternoon there will be a separate panel on collective countermeasures and all countermeasures. So probably the details will be discussed there. But what I can say is that, there are two different questions. One question is whether collective countermeasures are legally possible. And another question is whether we should use them in a particular situation. And that is, of course, a political decision. But if we look at situations where states, responsible states, are violating erga omnes obligations, they are violating jus cogens norms, then these norms, these obligations are a concern for the international community as a whole. And it's perhaps not practical to leave this to the direct victim state alone to address this violation, because everyone has an interest in protecting these obligations, these norms. So collective countermeasure is one possible option. Take, for example, use of armed force. We agree that collective self-defense is allowed. Yeah? We also agree that retortions are allowed. But why do we exclude from the middle, possible collective countermeasures? So once again, it's a question of whether this is legally possible, not necessarily that we have to use them in every situation. Yeah.
I know, Mohammed, you were shaking your head. Do you want to say something?
No, because I think Renee captured it very well. There's a policy question of what do you do when you have perhaps a country that does not have the capacity to, on its own, defend or deter against malicious cyber conduct by a state or non-state actor. That's a policy quandary. But then at least, this was the conversation perhaps in the African Union, is that since the Nicaragua case, the International Court of Justice indicated that while, exactly as you mentioned, right, that collective self-defense is permitted, but collective countermeasures are not. And in the discussion on the Articles on State Responsibility, Article 54, on the question of what do you do when you have a violation of a jus cogens norm that has the status, I apologize for the more nerdy conversation, but the question was, is it legally prudent, and is it also prudent from a policy perspective to open the door to escalatory behavior? Where you can start permitting collective conduct in response to a previous unlawful act where those reacting are not the injured party. And because it's such a contentious debate, sort of the African Union was like, let's leave that to the states, because we did not feel that there was enough opinion juris and practice to indicate that there was an established rule, that it's still contentious.
Yeah, then many states have a different view, right? Canada, Brazil, and France, for example, disagree with collective countermeasures. But that's for another panel. Let's turn to Russell's question about the legal status. Kubo, do you want to take it?
Sure. I mean, to some extent, I'm going to just add to what Agnes already said before. We do have a section on the legal significance of national positions. It's found in the introduction. And so it covers some of the questions, Russell, that you raised, but it doesn't answer all of them, because after having these discussions at the roundtables, we also saw a spectrum of views among the states about this question. And so there were, on the one side of the spectrum, very limited, but there were voices that would say, these statements only have policy value, they have no legal significance. Those were isolated voices, but we heard those as well. On the other side of the spectrum were question marks from some states saying, are you sure that these position papers will not amount to a unilateral binding obligation on us when we issue this? And those were also isolated, and then we had the views in the middle, which covered exactly the questions that you raised. For customary international law, do they reflect opinio juris? That's less controversial, I think they do. But maybe also state practice, which is a bit more controversial. And then for the interpretation of treaties, do they constitute what we lawyers call the subsequent practice in the application of a treaty? But for that argument to be made, we would probably need to have a higher number of these national positions, which ties very nicely back to the handbook. You know, the more states follow this and adopt these national positions, the more this argument will be able to be made. So I hope that answers it in a nutshell, and we can continue the conversation afterwards.
And now the last question about which stakeholders should be involved in the process. Yeah, and sorry? And the law and policy question. Katsuhiko, do you wanna take that one?
Yeah. To put it very shortly, I agree that all and as broad as possible stakeholders should be consulted or heard. And in our case, as I'm the legal advisor, and actually my predecessor was the legal advisor, our sort of direct interaction or contact was mainly focused on the academic circles in terms of international law. While other, for example, tech sector or more broader industrial sectors, which might be more or less affected by the cyber operations, those sectors have had either informal consultation or dialogue with the relevant line ministries in charge, and it was those ministries and agencies who had the feedback from those different ministries to the discussions. Of course, it might not be sufficient depending on the different national circumstances of the different countries. So, but that's what we did in Japan.
Great, thank you so much for that. We have reached the end. I can see the red screen here saying 0 time. So we've run out of time. This was a fascinating discussion. As you can see, there are lots of topics that still need to be unpacked. You can read more about them in the handbook. It's a complicated process. The questions are complex. They're debated. There are disagreements. But you know, the bottom line is that the process in and of itself has value to states in many, many ways. And even if states don't get to agreements, you know, they don't get to find common ground, at least they are, you know, at least debating these topics. And we need to know what states think to be able to identify areas of agreement and disagreement. So that's the value of these positions. And we hope this handbook will contribute to states, you know, reaching those agreements or at least coming together to discuss those issues. So can you please join me in thanking the panelists for now, but don't leave the room. Don't leave the room just yet. I have an announcement to make. I must not forget it. For those who are interested in the handbook, there is a QR code that will be made available here on this screen for you to download the digital version of the handbook and read it, you know, on your flight, maybe home. And for those who want a physical copy of the handbook, for those who are old school and like paper like me, there are some copies that are available outside at the CCD-COE at the CyCon booth. And if we run out of those copies, we didn't bring hundreds of them, there is a list that you can put your name on, and we will make sure that you get a copy. Thank you once again for attending this session. We are very, very pleased to have launched this handbook, and we hope you enjoy it. Thank you.